Hello everyone. Let's discuss today some interesting proposition of law, and which is that if the High Court has passed any judgment and you have filed a special leave petition in the Supreme Court, and if suppose that a special leave petition has been dismissed by the Supreme Court and then the another party is not complying with the order, question arises that where will you file the contempt petition? Will you file the contempt petition in the Supreme Court, or you will file a contempt petition before the Honorable High Court? This is called the doctrine of merger applicability in contempt petition before the Honorable Supreme Court. So there are various ambit under this, and we have to understand one by one. First is when Supreme Court in SLP has allowed your SLP, in that situation the doctrine of merger will apply and you can file a contempt petition before the Honorable Supreme Court. Second category is when Supreme Court has dismissed your SLP without giving any reason, in that situation the doctrine of merger will not apply, and it means you have to file a contempt petition before the Honorable High Court. Third proposition is when Supreme Court has dismissed your SLP with speaking order, means assigned the reason but has not altered or modified any High Court order, in that situation also doctrine of merger will not apply and you have to file a contempt petition only before the Honorable High Court. And fourth and interesting proposition is that when Supreme Court, while dismissing the special leave petition, has altered or modified the impugned judgment and order, in that situation it will be considered that the High Court order has merged with the Supreme Court order, and then you can file a contempt petition before the Honorable Supreme Court. The fifth proposition is Supreme Court, while dismissing your special leave petition, has laid down some proposition of law but has not altered or modified the order. In that situation you can file a contempt petition before the Honorable Supreme Court, not because that the order of the High Court has been merged with the order of the Supreme Court, but because of the fact that the authorities have not complied with the law laid down by the Honorable Supreme Court while dismissing the special leave petition. So these are the criteria and you may use that in your particular case. The relevant judgment for this is V. Senthur and another versus M. Vijay Kumar IAS 2021 Supreme Court. See you tomorrow.